All persons having business before the Honorable, the New Mexico Supreme Court, are admonished to draw near and give their attention, for the court is now sitting. Please be seated. Is the petitioner ready?
Petitioner is ready, Your Honor.
Is the respondent ready?
Respondent is ready.
The petitioners will approach the podium or bench.
May it please the court?
It may.
I am Counselor Rocco. Thank you for having me.
Thank you, petitioner.
On Wednesday, January 5th, 2015, the petitioner, Taylor John, posted a tweet alleging misconduct and harassment by a Lake Agricultural High School coach teacher, calling attention to his alleged harassment of female students, and later posted this to his public Facebook page. The coach saw the tweet and immediately brought it to the attention of the principal, who also brought the superintendent into the matter. The next day, the petitioner was called from a class, questioned about the post, and then sent home for the remainder of the day. John returned to school the next day and was informed that he was suspended from all school and school-related activities until further notice. This disciplinary committee directed that the tweet constructed harassment and intimidation of Coach White and violated the school district's policy and state law. He was transferred to the district's alternative school for the remainder of the grading period and would not be allowed to attend school or any school events, such as prom and graduation. Argument 1. Lake County School Board's decision to punish Taylor John did in fact violate his First Amendment rights. The Tinker rule, in which the foundation of the defendant's argument is based on, does not apply to the circumstances of this case, as Tinker v. Des Moines requires in the incident to either disrupt classwork or involve a substantial disorder of the classroom and be reasonably understood by school officials to threaten, harass, and intimidate a teacher, even if it was originated off campus. These prerequisites aren't, however, met. Taylor John wanted to bring awareness to an issue, and although the actions Taylor took to bring about this awareness were not the best course of action, he never intended it to be a threat. He only wanted to bring light to an issue that he saw happening within the school community. And in doing so, he directly tagged the school, specifically stated in the disciplinary committee's hearing that he only wanted to, quote, increase awareness of the alleged misconduct, end quote, and knew people were going to listen to it. The student was only seeking to raise awareness of a situation that he believed needed to be addressed.
Could it be said that because Taylor John tagged the coach, it was intended towards the community?
Yes, he did tag the coach, and yes, it could be directed towards the community, but it was the greater community, not just the school, therefore falling outside of the jurisdiction of the school. Furthermore, the interpretation of Taylor's posting is also misconstrued in how the school decided to approach Taylor's intentions behind it. He never truly tried to intimidate or harass. He simply warned Coach White of what would happen to him if people found out about his actions.
Administration did not ask the student to make threats. Therefore, isn't their disciplinary practices of the student justified?
If the actions of the students had clearly taken place within the school jurisdiction, yes. However, the jurisdiction of the case was not really entirely in the hands of the school. Argument 2, Taylor John's actions are not against school policies. The posting never explained any sort of violent behavior, and he also didn't say anything to make us think that he did. In Bethel District v. Frazier, it states, quote, maintaining security and order in the school requires a certain degree of flexibility in the school disciplinary procedures. The school took action immediately, and the principal was informed outside of school hours. Taylor John, therefore, also never had time to substantially cause disruption. We violate Taylor John's First Amendment right by disciplining him, and we show him that issues could potentially be dangerous and should not be brought to light. Taylor John never caused disruption in his learning environment and never disturbed the environment of others. When an issue affects the community tends to take action. In this case, the school got involved in a community issue that should not have been resolved on the school premises. By punishing John, they affected and disrupted his learning environment, and his learning environment affected him as a student. While directed at the school community, it is not plausible to apply the Tinker rule, as it does not apply as a reasonable disruption or as a proper threat against faculty.
Thank you, petitioner.
May it please the court?
It may.
I am Counselor Whitford. On Wednesday, January 5th, 2015, the petitioner, Taylor John, posted a tweet alleging misconduct and harassment by Lake Agricultural High School coach-teacher, calling attention to his alleged harassment of female students, and later posted this to his public Facebook page. The coach saw the tweet and immediately brought it to the attention of the principal, who also brought the superintendent into the matter. The next day, the petitioner was called from a class, questioned about the post, and then sent home for the remainder of the day. John returned to school the next day and was informed he is suspended from all school and school-related activities until further notice.
Since it was through social media and not in school, could it be assumed that Taylor John was within his own right to do what he did?
Although it was outside of school hours, it was still directed toward the school community through the tags in the post involving the school image. Disciplinary committee decided that the tweet construed harassment and intimidation of Coach White and violated the school district's policy and state law. He was transferred to the district's alternative school for the remainder of the grading period and would not be allowed to attend any school events such as prom or graduation. Argument 1. The tweet was aimed at the school community because the appellant tagged the school and the coach in the tweet, as well as reposted it to the Facebook page because he knew students would see the tweet stating, quote, "Students all have Facebook." In the words of Justice Oliver Wendell Holmes Jr., quote, "Free speech would not protect a man falsely shouting fire in a theater and causing panic." Certain forms of speech that may have been otherwise protected by First Amendment rights may not be protected in the school setting because, quote, "Constitutional rights of students in public school are not automatically coextensive with the rights of adults in other settings." John's tweets may have been protected by the First Amendment had it not been directed at the school community and reasonably understood to be threatening, harassing, or intimidating a teacher.
Since the student never truly took any violent action, how do we know that the post was a true threat?
How do we know he would not have eventually possibly hurt the coach? The intent was clear in the testimony of Taylor John, therefore that threat was not protected freedom of speech. Argument 2. The tweet forecasted a substantial disruption by the appellant and further interrupted the educational process by requiring quick action that diverted administration's attention to deal with the issue. By bringing the public into the situation and also not bringing the potentially seriously matter to the attention of the school authorities, John did not give the school a chance to respond to the situation and resolve it in an appropriate manner. With such a sensitive topic as sexual harassment, the community was bound to react harshly and possibly jump to extreme conclusions which would have affected the school and the education of other students. This is proven by the fact that John mentioned that at least 2,000 people had contacted him in reaction to the tweet on multiple social media platforms. Tinker does not apply in this situation because the tweet was intentionally directed at the school community as the appellant admitted to posting the tweet to Facebook, quote, "because he knew that it would be viewed by the students," end quote. And the part of his motivation for the tweet was to, quote, "increase awareness of the situation." He knew that students would see the tweet by posting the tweet in hopes of getting students' attention. Petitioner stated that the wording of the tweet was simply a warning and not a threat. However, the exact words were, "he better watch his back," to make a clear intent of possible harm. The tweet was not the only option the student had to create awareness of the issue, therefore the student was in the wrong by posting the tweet. Also, since the school faculty and multiple students were involved in the issue, the school has every right to take action without impeding the rights of Taylor John. Thank you.
Thank you, respondent.
May it please the court?
It may.
The respondent made a few statements that could be misinterpreted. Firstly, they believe that since the school and coach was tagged, it immediately placed the issue under school jurisdiction. That is not true since it did happen outside of school hours and the student was using a social media account not directly regulated by the school. Additionally, the disruption caused happened unnecessarily since the issue should not have been needed to be handled by the school.
The justices will now retreat to make their decision.